the rodeo picked this fight, not us, and for really bad reasons. And that's what this whole case amounts to. They wanted the fight, they picked on the wrong two people.
Jeff, how did we get here? This fight has gotten out of control. How did we get here?
It has, and there's two answers to your question. The short answer is the rodeo picked this fight, not us, and for really bad reasons. The long answer is sort of the procedural explanation of what's happened, and I'm happy to go into that if you'd like.
Yeah, let's walk people through how we got here.
Okay, so the one thing that I've seen so far that people have difficulty understanding is there's essentially two cases. They are related, yes, but there's two cases. So Breanne Williams sues the rodeo and the Los Vaqueros Trail Ride Group at issue in that case over the rape that she was the victim of, right? And as of course you'll remember, her lawyer contacted you to do essentially a media investigation to look into some of the issues and look into some of the history with the rodeo with similar events. Well, as you did, which is your right, you served records requests under the Texas Nonprofit Corporations Act, which is part of the Texas Business Organizations Code, that says if you are a charitable organization, you have an obligation to produce your financial records. And the purpose of that statute, as it says in the statute itself, is we want to hold charitable organizations accountable for their spending. Why? So that they're not acting like a for-profit corporation, but seeking the protections of the law as a nonprofit. So when you send records requests saying we want to see your financial records regarding these expenses, all of which we're sure are problematic for them, that's when the rodeo decided to pick a fight, and that's when they decided to sort of approach this whole thing in a whack-a-mole style defense strategy.
They have come after me not once, not twice, I think 3, 4, 5 times. I'm losing track. So can you walk people through how many shots the rodeo have taken to protect these secret charity records?
It's funny you phrase it that way. That's why I call it a whack-a-mole style defense strategy, because sort of every time you pop your head up, the rodeo files something to try to whack you down and keep you from getting any further with this investigation, right? So the first attempt, as you recall, is when you send records requests. Essentially, the rodeo contacted you and said, stick it up your you-know-what. We're not going to produce you anything. And then turns around and files what was their first attempt, which is a motion for protection in the 334th Judicial District Court, which is presiding over the underlying rape case, of which many of your requests were relevant to. So that court denies their request for protection. And as you continue to speak out about the rodeo and what they're doing, and they're acting as a business instead of a charitable organization, they then take a second approach, which is they go back to the same court, the 334th Judicial District, and say, look, Judge, we know this case is ready for, about to get ready for trial, but we want to add in Dolcefino as a defendant.
And the rape victim.
And the rape victim, and we want to sue them regarding these records requests to determine, what we got to do and what we don't. And really what that means is to say we want to try to not produce any records.
Yeah, they wanted to sue a rape victim for money as a way of trying to keep their charity records secret. I talked about that. I found that to be disgusting. I told the rodeo, I'm a big boy. You want to fight me? One thing, I think the rape victim has suffered enough. Then they keep going.
That's right. So they take that to the 334th, who says, look, I'm not going to allow you to add him into this case at this minute in time because of the potential that it may delay the trial setting, which is an injustice to the rape victim. And that case needs to go to trial. It's been on trial for a while. It's been in litigation for a while now. So follow that. You continue to speak out, and you continue to do videos and press releases, and then the rodeo gets more aggressive, and they immediately turn around and file a second case against you, which is the case that all the machinations are happening about now.
And so the law says when a charity does not give you your financial records, it is a crime. And I filed a criminal complaint, which is now being investigated by a special prosecutor appointed by a judge to investigate my criminal complaint, which was made in good faith. That's what the law says to do. I've done it before, we'll do it again. The rodeo then sues me and admits that they're suing me in part because they want to go after me for filing the criminal complaint.
Well, that's right. And in fact, a big part of the rodeo's case is, Judge, please declare that we're not in violation of this criminal statute from the Texas Penal Code, which you can't do. But that's what they're trying to do, to get an order from the district court saying, oh, but we didn't commit a crime, and would you let us know in your case and in your court that we didn't commit a crime, which the criminal courts have jurisdiction over, which is why it was odd. And in their petition, they essentially admit that this is being done because you're speaking out. They actually refer to press releases. They even attach press releases to their petition, which is a tacit admission that we're doing this because Wayne is exercising his right to free speech.
I think that's a crime too. I think retaliating against someone who files a criminal complaint in the law books is another crime.
It is, and in fact, that's one of the reasons why we filed our motion under the Texas Citizens Participation Act, which is otherwise known as the anti-SLAPP statute, that essentially says if you're exercising your right to free speech over a matter of public concern, which given the magnitude of the monolith that is the rodeo, is a matter of public concern in this jurisdiction, they cannot file a lawsuit in retaliation against you, which is essentially an attempt to silence you. And when you look at the history of the transactions here, that's the rodeo, what the rodeo has been doing. Every time you speak out, they try to whack-a-mole you down back into the ground.
Okay, so we go back to court, and there is an announcement that the rodeo case is settling for upwards of more than $500,000 to the victim and her lawyers. And we have a fight because we say that's the judge, Judge Kirkland, who knows a lot about this case, and our case, regardless of whether the rape case is going away or not eventually, needs to stay in his court. The rodeo, again, loses that fight, and they don't like that judge, so they went to the appeals court, right?
Right.
To stop it. So where are we now?
That's a bizarre answer, actually.
Yeah.
And here's why.
Okay.
So, as you'll recall from the hearing in the 334th Judge Kirkland's court, when they tried to add you as a defendant at that time, what he said was this really should be a separate suit, but I know when you turn around and file it, it's going to have to end up back here.
Right.
So, as you recall, when that did occur, procedurally, we said, okay, apparently we have to be in this other court, so we've requested the transfer consolidation of this case into the court that said we're the ones that need to hear it.
Right.
So we do, and the judge agrees with us and transfers the case into his court. That's when it gets even more interesting, because now all of a sudden the rodeo is upset with the fact that your case is getting transferred into the court that they were seeking protection from. Bizarrely, in their petition for mandamus, they accuse you of forum shopping, saying, oh, well, he's just trying to go into the court that he wants to be in, which oddly is the court that they sought relief from.
They started this fight, I didn't.
Right, so when the new case gets filed over the records request, which we should talk about what that is, but when that happens, they decide, I guess, that they like the other court better, or they no longer like the court they were seeking relief from, I guess because he didn't agree with them, at least at some point. Now they want to oppose it, so they file an emergency petition with the Court of Appeals to say, oh, the 334th should have never retained jurisdiction over this, and they never should have transferred it back in, even though everybody else thinks that they should have. So you need to undo that so that we can go into this other court that apparently we either like better or just don't like the first court. Oddly, what they're doing in doing that is trying to choose the court that they want to be in for whatever reason they want to be in that court, whether it's they don't like the 334th or they like the 113th, which is at its very definition, forum shopping, which is what they accused you of in how they got their relief. And then to make matters worse, in their appellate court brief, seeking relief from this, they make a number of misrepresentations about what's going on in this case in order to obtain that relief.
Yeah, I mean, they lied.
Yes.
They lied to the appeals court.
Yes. In my opinion, that's exactly what happened.
Okay, so when's the next hearing on this? Or is it all frozen now until the appeals court decides where it stays?
Well, the Court of Appeals opinion leaves a little to be desired in terms of clarity. So what we know is that they've stayed the order transferring the case back into the 334th, but we don't know, of course, if that means that that court still has jurisdiction over it but can't go forward, or whether that was the Court of Appeals' attempt to undo that order and send the case back to the 113th.
I have a law book to figure this stuff. Let me tell you something. One of the frustrating things about this for me is that the idea that any charity who gets donations from people and brags about how much they do for kids and agriculture, why in the world do they care what their financial records show? I don't understand this. They want the protection of the tax laws. They want to get all these volunteers to give their blood, sweat, and tears, admittedly during a good party, but their blood, sweat, and tears, because they're helping kids and sending kids to college, and then they fight a simple request to see how they spend the money.
The direct answer to your question is it's got to be because they don't want anybody to see that they are not functioning as a charitable organization. But to better understand that, for people who may see this, what's really going on and what the central fight is between you and the rodeo at this point is they're doing everything in their power and wielding as big a stick as they can find to try to prevent the disclosure of the financial records, making them accountable for their expenses. Now, the rodeo would have you believe that, oh, we're trying to get into all kinds of confidential things and they want to know the donors, people who donate money. Never been the case.
Right.
All of the requests seek information regarding the expenditures, and the statute and the various court opinions that have interpreted that statute say the whole purpose of this is to hold charitable organizations accountable for their spending, not their donors. We don't care about that, but we do want to hold them accountable for where they're spending their money. And if they're not spending their money in a manner consistent with a charitable organization, there's serious ramifications for that.
You've seen people fight before, but in my business, when I see people fight this hard to keep a secret, there must be something to hide.
Almost by definition. Transparency is usually a very good indicator that somebody doesn't have something to hide. When they put up this much of a fight to prevent you from seeing something, you have to understand that that's only because they really don't want you to see it. So now we're in an interesting position here where we don't know where this case is going to go forward yet. The 113th has indicated, at least as of right now, that they're not sure whether they have jurisdiction over this case or not. The 334th has apparently taken the position that we may not be able to go forward, but we have the case. We're just stuck in that the case has stayed, but in our court. So neither court really knows who has jurisdiction over it or who has the ability to go forward.
And meanwhile, the rodeo, paying their high-priced lawyers, is probably spending thousands of dollars a day that they could have given to some underprivileged kid to go to college.
The numbers have to be staggering. I mean, first of all, they hired what's probably one of the most expensive law firms in town. They're certainly in the top 5. And they have at minimum 3 lawyers that I'm aware of that are working on this. Because even in their Court of Appeals opinion, they have 3 lawyers on the pleadings. 3 high-priced lawyers seeking protection to keep you from seeing the records that indicate where they spent their money, and there can only be one reason for that. The bill in this case to the rodeo could be staggering, which is all money that could be going for their alleged charitable purposes. And while we're on the subject, let's talk about that, because that's the biggest thing that I have an issue with. Aside from the fact that they could have just said, sure, we don't have anything to hide, take a look at these records you want to see, there's nothing there, whine about it all you want to, everything we've done is perfectly fine. They're not doing that. They're spending what could be over $100,000 trying to prevent you from seeing it that could put any number of kids through school, which is what their stated purpose is. But it doesn't stop there. Aside from the things you've reported on, let's address the fact that the rodeo has available on their website a 103-page financial economic impact study that is nothing other than an ego study designed to show what the financial impact is of the rodeo on the Houston market. How much more commerce, how many more jobs, how many things that they're doing, all of which is great if they have that benefit, but just have the benefit.
Right.
They have to have spent hundreds of thousands of dollars in the development of this 103-page study that does nothing other than say, yeah, you really are great, and let me talk about how much economic impact you're making. If you're a charitable organization, in what universe does that matter? Bring the money in, give it to your charitable causes. That's what your function is. It's not to decide how big of a horse you are.
And finally, that's really why this fight is so important to me now, because if they get away with this, then the charity laws, the transparency of the charity laws are gutted.
That's one of the single biggest impacts that this case could have. Okay? Bad decisions can make bad law. The rodeo, in my opinion, is making a very bad decision, and I can tell you from commentary that I've got that a lot of people are upset with how the rodeo is handling this. But in their action, in their lawsuit against you, they're seeking the court to interpret a statute in a way that says you really don't have to give financial records that will hold you accountable. The rodeo tried what was a parlor trick, in my opinion, to try to circumvent all of this by providing you 6 boxes of what they call their general ledger that you can look at and see a bunch of numbers, but you can't tell where they spent it, which doesn't tell you anything.
Or what?
That's
or
right.
They spend it.
Who they spend it on, what was the purpose for the expenditure, and was it a legitimate purpose or not? You can't tell any of that. But then they want to go to the court and say, oh, but we produced all these documents. And Judge, even though the statute says we have to produce financial records, we just interpret that to mean that we only have to give this top-level general ledger that doesn't provide any information, when the purpose of the statute says is to hold them accountable for their expenditures. It's a cheap parlor trick of burying them with a bunch of paperwork claiming that you've complied when you've not in any way complied with the purpose of the statute. If this goes the wrong direction, whether at the trial court level or at the Court of Appeals level, it can gut the law that holds charitable organizations accountable for their expenditures, which means they can seek protection from the law, protection from federal tax laws, allowing them to make money that they do not pay tax on, allowing them to not be accountable for things that they're doing when they're functioning as a private business, getting the protections of a 501c3 charity. Meanwhile, they're only acting as a for-profit corporation designed to line their own pockets.
It's becoming obvious that they think they're a sacred cow.
The power wielding that they're doing, which I do want to address before we stop talking, is significant to me, and I'm seeing things in the rodeo that bother me. For example, everybody knows that there are committees made up of volunteers for the rodeo. Many of them are lawyers, many of them, which they have free access to for advice on matters of legal concerns. Oddly, they're now employing a general counsel as a full-time member who's making what I understand to be, and I haven't verified it, hundreds of thousands of dollars a year,
right,
serving in this function when they have access to thousands of lawyers who have volunteered their time to the rodeo that could advise them and would be happy even to do pro bono work, which I'm sure is not currently occurring with the firm that they've hired,
right,
to help the rodeo on an as-needed basis when people go after them. That's what they could and should be doing. Instead, they're employing more and more staff, spending money every year in lieu of volunteer work that could be going to their charitable causes. But it doesn't stop there. The power wielding that's going on, to me, has gotten out of control. And I'd like to address the allegations that we've made regarding the rodeo filing criminal complaints against you.
Go ahead.
So that is a very, very interesting set of facts as far as I'm concerned. And since all of this is public record in the affidavits that we filed, what I can remind you of is what we understand happens is that somebody or people file a groundless criminal complaint against you saying you're acting like a private investigator when you're clearly not doing anything that every reporter in the history of the universe has not done. So an allegation gets filed, a criminal complaint gets filed, and the district attorney's office appoints a special prosecutor who calls not one but at least two people that I'm aware of, because they filed affidavits saying, this special prosecutor called me to discuss these allegations, and in that conversation told me, as well as in a separate conversation another person, that the rodeo is one of the people who filed a criminal complaint. So off we go. Now, of course, the indication that we've gotten from them is this is a groundless complaint. We don't intend to do anything about it. But we bring that up in the context of our anti-SLAPP motion saying this is the rodeo retaliating for Wayne Dolcefino speaking out. We show up at the hearing, and what the rodeo says is, oh, well, Mr. Diamant should now be clear that the rodeo didn't do that, because we have reason to understand that the special prosecutor who told them that the rodeo filed a complaint has now told them contrary. But we, Judge, we think that's all resolved now. And what you may recall that I said to the court was, Judge, I don't know that at all. Let me tell you what I know. What I know is that the special prosecutor told not one but two people that they filed one. And then what I know is the day before or 2 days before we're supposed to have this hearing, the special prosecutor calls you and says, oh, remember what I told you? Like, never mind. Like, in the words of Willy Wonka, strike that, reverse it. Right? By the way, I got a phone call from counsel on behalf of the rodeo. And having talked to that counsel, I now need to call you and clarify that I told you that the rodeo filed a criminal complaint. But what I really meant is that they didn't file a criminal complaint.
So where do we go from here?
Well, at this stage, they pick the fight. There's only one way to see that through. So what's going to happen now is somehow or another there's going to be some clarity as to whether this case is going forward before the Court of Appeals rules, or whether it's going to wait until after the Court of Appeals rules as to which court has jurisdiction. Either way, at that point, there will then be hearings on the rodeo's attempt to obtain a judgment as a matter of law, which they're not entitled to legally, as well as our anti-SLAPP motion saying, Judge, they can't do this. You have to dismiss the rodeo's action against Mr. Dolcefino and pay him attorney's fees for having filed it.
So the rodeo is clearly coming after my firm. They want to do economic harm to my firm. And with your help, I want to send a message that not only will that not happen, but they will suffer the financial consequences for doing it.
Absolutely. You do something like this, you wield power in a manner that's an abuse of that power, when as a charitable organization, the word power should never enter their vernacular at all, right? That is not the purpose of a charitable organization. It is to do charity, not to wield power. It's not even to have power. And the fact that they're doing that and they're exercising their power in this community in the manner that they're doing it needs to be addressed, and they ought to be punished for it. At the bare minimum, what the statute provides, which is for you to get your attorney's fees paid for having to defend this, which in this case, they're not only seeking the opposite, but they want you to pay their attorney's fees to deny you access to the financial records that the state of Texas says they have to produce. And then they've hired a whole gaggle of very expensive lawyers to do it, which could run easily into a six-figure bill that they want to stick you with, who's really just the guy saying, I want to know where you're spending the money because people want to know where you're spending the money. And that's what the whole issue is here. And that's what this whole case amounts to. They wanted to fight. They picked on the wrong two people.